Hello there, Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. Today we're going to talk about something that's strangely fairly absent on this channel, administering a trust after someone has passed away. I say strangely absent because not only is trust administration after death a large practice area of Bethel Law, it's actually where the majority of my personal legal work lies. Yet, aside from one video on the required notice to beneficiaries after death, I haven't really talked about trust administrations. So today, we're going to rectify that. However, a little primer before we get into the details. Trust administrations are not quite as formulaic as establishing the trust in the first place or going to probate court. Perhaps that's why I haven't really talked about it in particular. However, what I mean by that is that even though there are steps that must be taken in almost every trust admin, the structure and how we address particular assets can often vary wildly, even between branches of the same bank. On top of that, while we do have to deal with the personalities of the beneficiaries in a trust admin and a probate, it seems to be more, shall we say, involved task during a trust admin. I think this is due to the fact that since a trust admin is not a court process, the whole point of setting up the trust in the first place is to stay out of court. There aren't ongoing filings and notices sent to every interested party. A trust administration is, by its very nature, a private affair, and thus if you have a troublesome beneficiary, they seem to be extra troublesome because a judge isn't looking over the successor trustee's shoulders. Also, if that troublesome beneficiary lawyers up, their lawyer becomes troublesome, but with an extra bite, since they know what buttons to push and they're really looking over the successor trustee's shoulders. The lawyer needs to make themselves useful in order to justify their relatively easy position of being the beneficiary's lawyer, who gets to sit back and audit the administration process without doing any of the actual work themselves. By the way, I almost always represent successor trustees in the administration, so I'll leave it up to you to decide whether or not that colors my opinion on lawyers who represent the beneficiaries or not. Lastly, because there's not as much of a defined structure to a trust admin, there are duties I'll discuss that can be done simultaneously with other tasks or somewhat interchangeably. However, there are two duties that are on a timeline: providing an accounting, which I'll discuss at the end, and providing notice to the beneficiaries, which we'll get into first. So settle in, hit the like button, subscribe, and share the video with your trustee, and let's dive in. As trustee or successor trustee of a trust, you have some defined duties that you will need to adhere to when administering a trust. I won't be going over all of them in detail in today's video. That's a topic for a video all on its own. But an important duty to know about is the duty to provide notice to heirs and beneficiaries, those with an interest in the trust. These interested parties are going to be natural heirs of the decedent, such as children or potentially grandchildren, and the beneficiaries of the trust. Typically, these people are one and the same, but let's say mom disinherited son yet also left something for her niece. Then both the son and niece would need to receive notice. These interested parties are also entitled to a copy of the trust and your last will and testament. Yes, even if you disinherited someone and they are a natural heir, they are entitled to notice of the trust and a copy thereof. Now, the reason we're starting with this notice requirement rather than something you'd expect, like figuring out what the assets are or contacting utility companies, is because this notice is one of the few things we're on a strict timeline for. California Probate Code Section 16061, which is all of this, sets out the specific requirements for this notice, including some of the specific language, the timeline in which this notice must be given, how long the recipients have to challenge the trust, what they can do to extend that challenge period, and even goes as far as to specify the font size. I've discussed this notice requirement in depth in really the only trust administration focused video on this channel previously, so I'll link to that video in the corner. However, what you'll need to know today is that the successor trustee must provide this notice to the interested parties within 60 days of that trust becoming irrevocable, which likely means 60 days from date of death. That notice starts a clock. The recipients have 120 days from the day they receive that notice to challenge the validity of the trust before they are precluded by law from challenging the trust thereafter. However, those interested parties can toll that deadline by an additional 60 days by requesting a copy of the trust and will that they're entitled to anyway. Thus, it's always best practice to simply include a copy of the trust and will when sending the notice letter initially. Successor trustees should also send this notice by certified mail with the return receipt so that they have a physical record as to the date the notice was received. Due to the deadline of having to provide that notice within 60 days of date of death and the 120-day window of the challenge period, sending this notice is something that trustees should try to send out as soon as possible. There may be cases where everyone is going to play nice with each other and not force anything to be stuffy and formal. However, as a blanket rule, I would say to send that notice as soon as the successor trustee is able to acquire a copy of the trust and will, but no later than 60 days. If a beneficiary or two are difficult to locate, then there's no sense in delaying the sending of all the notice letters. The trustee should just send the notice letters once they're able to ascertain most of the contact details for the beneficiaries and catch up with the stragglers when they can. Next are going to be the group of tasks that I mentioned that may be done simultaneously or one after the other. Those are going to be things that one would expect a successor trustee to have to do. One example is securing any assets like a house by acquiring all keys, knowing who has access to said house, and if need be, changing the locks. The successor trustee must also ascertain what assets are out there, which may not be readily apparent at the onset of the administration. The trustee will need to dig through the decedent's records as well as their mail to catalog what assets the trustee will need to address. This is becoming harder as more and more statements are going paperless. Hopefully the decedent kept diligent records as to what their assets were. One way we've had successor trustees find assets is by simply checking bank records to see where money is being transferred, or for instance, if a life insurance policy is being paid. Another is by looking at past tax returns for information as to what brokerage or retirement accounts the decedent may have had. Next, we'll be notifying third-party companies that the decedent has passed away. Some examples of these would be utility companies, financial planners, and Social Security. Oftentimes, Social Security finds out someone has passed away because the mortuary will inform them. However, it's not a bad idea for the trustee to still reach out to Social Security and inform them of the person's passing. The trustee should keep in mind, however, that if the decedent did receive Social Security benefits in the month in which they passed, those benefits will need to be returned to Social Security. Social Security does not prorate payments in the month in which somebody passed away. During these opening stages, the successor trustee should also acquire an EIN for the trust and open up a trust bank account to begin collecting or marshaling the trust funds therein. All accounts of the decedent must be closed down and all funds must be moved into this new trust account. An extremely common question I get asked is, why do we have to do this? Why can't we just continue to use the existing accounts? Well, if you thought you were going to escape an Andrew Bethel video without me mentioning taxes, then I'm sorry to say, this movement of funds is for tax reporting purposes. As the decedent is now, well, dead, we can no longer report financial activity on their personal Social Security number and thus their personal tax return. Therefore, the activity occurring from date of death onwards needs to be attributable to the trust EIN and thus the trust tax return. An EIN can be acquired online from the IRS's website fairly quickly, however not fairly simply. The online form will give you an EIN within a couple of minutes online as a PDF. However, the form itself is not terribly intuitive if it's not something you've dealt with before. I do have a video where I've discussed this and what you'll need to do to acquire an EIN, so I'll link to that in the corner for more details. The next stage of the administration is what I'll call the big middle. It's the middle of the admin where we'll likely spend much of our time, depending on the size and complexity of the estate. Yet conversely, it's where we're not going to spend much time in discussion for this video. That's because it's in this stage where the successor trustee has the original death certificate on hand and they're closing down accounts and transferring money to the trust account they opened with the EIN. The successor trustee will notify banks and financial institutions of the person's passing and either collect the funds or connect the company with the named beneficiaries for a direct distribution to those. If there is real property, then now is when the home is getting ready to either be sold or transferred to the beneficiary or beneficiaries. In either case, an affidavit death of trustee will need to be recorded with the local county recorder's office to remove the decedent's name from title and evidence who is the current successor trustee. If the house is going to be sold, then escrow can prepare this affidavit as part of the sales process. If the house is going to be kept and transferred to a beneficiary, then the successor trustee would record a grant deed transferring the property after recording the affidavit. Going further, if there are personal items, then now's the time to address those. Transfer them to the beneficiaries, sell them if nobody wants them, and either toss or donate the remaining personal property like old furniture or clothing. If the decedent made directions as to certain personal property, then follow their instructions. If not, then the personal property is to be distributed pursuant to the percentage shares in the trust. The beneficiaries will often have some desired personal property like mementos or collectibles, but otherwise, this is something that's often simply addressed within the family. Now, it's often in this big middle period, the challenge window for interested parties to challenge the validity of the trust should be closing. Successor trustees should be sure to keep accurate timelines and records so that they know when the final challenge window does close. In order to distribute funds, successor trustees are not required to wait until after the challenge windows have closed. However, it's best practice to either wait until the expiration of that period or acquire a written waiver of the challenge period from each interested party. You don't want to be in a situation where the trust needs to defend itself from attack yet has no assets from which to pay to mount a legal defense. This brings us to the late game and another important duty of a successor trustee, the duty to account. I like to think of it as two separate duties, being the duty to account, as in keep accurate records, and the duty to provide an accounting. However, that is also something for its own video, so for now, just know that trustees must keep good records and account for the trust activity and assets. Throughout the process, the successor trustee should be keeping diligent records as to all transactions that have been occurring within the trust and the administration process. The successor trustee should also acquire statements showing the value of the assets as of date of death. The successor trustee would then take all this information, compile it in their own records, and either present that accounting to the beneficiaries later in the admin process, or provide that information to an accountant to construct a court-formatted accounting to then provide to the beneficiaries. I won't go into too much detail about trust accountings in this video. Again, we'll save that for a later video. But just know that the probate code does set out the requirements of a trust accounting in section 16062 and 16063. The accounting will need to contain things that you would expect, however. Money that comes in, money that went out, the assets and liabilities, trustee compensation, and payments to professionals for their work such as the accountant or attorney. Additionally, the accounting must include an explicit statement that the recipient may petition a court to review the accounting under Code section 17200, and that claims against the trustee for breach of trust may not be made after the statute of limitations, which is 3 years from the date the accounting was provided. Successor trustees should also know that trust accountings must be provided to beneficiaries at 3 points in time. The first is when there's been a change of trustee, the second is 1 year from the date of irrevocability of a trust, and the last is when the trust is closed. From experience, the two most common cases where we are compelled to provide an accounting to the beneficiaries is 1 year from the date of death or irrevocability, as well as when the administration is done. If we are able to close the administration within a year, then we're just providing a trust accounting once. However, if the administration goes on for longer than a year, then we're providing multiple accountings to the beneficiaries during that time. And for completeness sake, a change of trustee is what it sounds like. When the person in the office of the trustee changes, then the next trustee in line will take over the administration process, and because there's been a change of trustee, the new trustee will have to provide an accounting of the activity of the prior trustee to the beneficiaries up to that point. An example could be where a successor trustee suffers a health emergency or passes away themselves. The next person in line as trustee will step in and take over the administration of the trust. One final note on the accounting for beneficiaries. Ideally, the successor trustee keeps accurate enough records so that they, or their lawyer, can prepare an accounting of the trust activity sufficient to satisfy the probate code and ensure that all beneficiaries are going to be kept at ease. If a beneficiary decides to lawyer up, then 99% of the time, we must have the accountant prepare a court-formatted accounting, which of course means there's extra fees going to the accountant and thus less money in the overall trust estate. I try to have my successor trustees heavily discourage the demand for a formal trust accounting because those beneficiaries will receive all of the same information that will be encapsulated in such an accounting without the extra expense of having an accountant put it in a particular format. Keep in mind, beneficiaries are not entitled to a court-formatted accounting. Beneficiaries are entitled to an accounting that must contain specific elements and information. A court-formatted accounting is just an accounting containing all the same information, but structured in a format that a probate court would want to see if a judge were to order or compel an accounting for a trust administration. Again, the same information, we're just paying extra for the formatting. Once most of the assets have been accumulated inside the trust and it feels as though we're nearing the close of the administration process, things start to slow down a bit. This is often where distributions are made and taxes are addressed. When we're at this stage, we are typically filing a final tax return for the decedent's personal taxes and a tax return for the trust. Most assets have typically been addressed, so it makes sense to go ahead and provide a preliminary distribution of the trust assets to beneficiaries. By preliminary distribution, I simply mean that it won't necessarily be the final distribution. This is because we are now waiting on the accountant and the government to process the taxes. There may be a tax bill to address, the accountant's fees to pay, and potentially a tax refund to collect. Thus, we often recommend successor trustees to keep a reserve of funds within the trust to address these final issues. We have found that around $10,000, depending on the circumstances, is usually a pretty good reserve in that it can address any surprise or unexpected expenses that may arise, as well as those anticipated expenses I just mentioned. Additionally, it allows us to keep the trust account open so as to collect any final money coming to the trust, such as a tax refund. Finally, after all the dust settles, whatever is left in the trust account is then divided and distributed to the beneficiaries according to their inheritance shares. And of course, trust accountings must be provided to those beneficiaries, and those are often done when making these distributions. Whew. Okay, we've made it to the end of the video. Now I understand if you made it this far and still feel uneasy or unsure as to what to do. Don't worry, this is just to give you an overview of what to expect when it comes to administering a trust. As I said in the beginning, the process itself is not as rigidly formulaic as a probate, so there isn't necessarily going to be an exact step-by-step process. You're going to be doing a lot at once. Just remember the timeline for the notice and the requirements for the accounting. I plan on doing more in-depth videos on many of the topics I've touched on in this video, but if you have any questions or something you want me to address first, then let me know in the comments below. I'd love to hear from you. Be sure to like and subscribe, share the video with your successor trustee. I'm Attorney Andrew Bethel, and I'll see you next time.